Hey, everybody. Happy True Crime Wednesday. Hope you all are doing well. Welcome. And it is Wednesday, day 11 of the Karen Reed trial. And it's starting to get a little juicy. So there's some things we might want to chat about. Some things we will chat about, frankly, but we have a few other things to talk about before we get to Karen Reed. First of all, please subscribe and hit the like button. And, hit that notification button so you get notifications if we go live at a random time. And we do occasionally do a surprise live if news warrants it. So let's dive in and talk about our favorite diva, Lori Vallow. She is asking for a new trial. Now, do I think she's going to get a new trial? No. But asking for a new trial is standard in any criminal case. It would practically be malpractice as a lawyer, except she isn't a lawyer, not to petition the court for a new trial. So that isn't surprising. She's also filed a motion having to do with the issue of the juror misconduct. I don't think that's going anywhere. Now, I have heard a lot of varying stuff about this juror. I just don't know how much of it is true. So it's really hard to judge at this point what's going to happen. The latest that I've heard is that the juror who claimed that that Lori claims knew about her prior convictions while still in the jury room. The story has come out from the juror that when the jury left the courtroom after having rendered their verdict, they went back to the jury room, and on the way, someone yelled to them, "You should Google Lori Vallow." And so when they went back in the jury room, some of them did Google Lori Vallow, and he did know by the time he walked out to talk to the media about her prior convictions. And I mean, technically, he did Google them from the jury room, but it was after they had rendered their decision. That is the latest that I'm hearing, but I don't know really. I mean, I don't know that anybody really knows for sure what happened. So we'll wait to see what the court does. But I think it's going to be another no harm, no foul kind of ruling from the court. So, her next trial is coming up. The jury selection will start on May 30th. She is still intending to represent herself. That is the conspiracy to commit murder case where the victim is Brandon Boudreaux. Her niece, Melanie Boudreaux, now Pulowski's ex-husband. So we'll wait to see what comes of that. As far as we know at this point, she is still representing herself. The state did file a motion notice that they intend to call Nick Balance. You may remember him from the Idaho case. He is the FBI's cell phone and data expert. He testified at both Lori and Chad's trials in Idaho about their cell phone data. He is, or at least was at the time of those trials, assigned to the FBI's district that included Idaho and Utah. I think their headquarters is in Salt Lake. But he is going to be called because he was the person who did all the cell phone extractions and did all of the GPS data, location data. And so he is going to be called in this case as as well in Arizona. So I did see that. Haven't seen any other pretrial motions on Lori yet, but I'm sure those will come because um, she's been filing pretrial motions in limine, all of those things. Now, my understanding is this same judge is going to be trying this case, so I don't expect that he's going to be any more, um, he's going to change his mind about prior rulings on motions in limine. So, but they still have to preserve it for the appellate process. So I'm sure she will be filing some motions in limine. There is some news in Donna Adelson's case, and it isn't necessarily great news, but recently the prosecution turned over to the defense a great deal of new data. It is an investigation that was undertaken into someone else. We don't know who. That person has not been identified. Although if I had to guess, I might guess that it's Wendy. So they recently provided something like 30,000 digital files, like emails and text messages and voicemails and those sorts of things that they turned over to the defense. I'm sure it includes recorded phone calls between Donna and Charlie. They never seem to be able to keep their mouths shut when they talk to each other. So the judge in that case asked the prosecution if all of that new information was going to result in them filing a superseding indictment on Donna, meaning that they were going to add or change the charges against Donna. And the prosecution said it was not going to result in that it may result in the indictment of someone else. So, because of that huge dump of information, the defense came back and asked the court for more time, and the judge said that he believed that that justified more time for them to be able to have the opportunity to review that information. So he set the trial out until the 19th of August. So it was originally set for next month, for June. So he's given them about another 60 days to be able to review that. Now, one of the great things about artificial intelligence, there are a lot of scary things about AI and a lot of suspicious things when it comes to plagiarism and artists' original work and all those sort of things. There are some good things to come out of AI, and one of them is the ability for AI to do the searches on some of this information, and to be able to flag things that the AI program believes warrant further review by the lawyers. It's I think it's new enough technology that most lawyers would think it was a little dangerous to let that be their only source, but I do think that it could provide a layer of filtering. Um, that's the job that young associates used to get, of sitting there and going through thousands of emails or thousands of records and deciding whether there's anything even remotely relevant in them, or whether they're all chit chats about um, what everybody's having for dinner. So we'll wait to see, but the judge also said that he would not agree to any more continuances. So absent something that can always change. I mean, judges often say no more continuances and then get stuck in a bind where they have to. I mean, one of those examples was in the Adelson case. the judge said, absolutely no more continuances. And then the whole issue of the conflict came up, and he ended up having to dismiss all of Donna's lawyers, and she had to get all new counsel. Well, that obviously was the basis for a delay in the trial. So, the judge always has to balance due process uh, versus moving the trial along. There recently was a trial or a pretrial hearing in the Shanna Gardner case, and it actually there wasn't a whole lot to it. They did have a pretrial discussion about discovery. The prosecution and defense said they were going to get together and do a discovery conference so that they could confirm that everybody's got discovery. There's still been nothing new from the co-defendant. The last time the co-defendant was in court, he blurted out that he was recanting his testimony, his confession to being the gunman that killed Jared Bridegan. So we wait to see what how that's going to impact her trial as well. But at this point, there still isn't. There is a firm trial date, and there's a status and pretrial conference for June 6th. So we'll wait to see what's going to happen there. There is a new Menendez hearing, I believe, on Friday. Today's the 7th. It's on the 9th. So we'll be keeping track of that and see what comes of that. In June, we have Crystal Rogers, Brooks Houck, and Joseph Larson are on trial for the murder of Crystal Rogers. That's a no-body murder case, and I think it's going to be difficult. I think it is going to turn on Joseph Larson's father also is accused in the case, but not being tried as a co-defendant, which is kind of odd. But I think the case is really going to turn on Joseph Larson and his father's testimony. Larry Millette is coming up in early July. That's another no-body case. James Craig, he's the Arapahoe dentist who's also been charged with witness tampering and conspiracy and a whole bunch of other things for conspiracy to commit murder, for trying to get an inmate to murder some of the witnesses that were involved, including a law enforcement officer. And then, of course, the biggie, Brian Kohberger. That jury selection is going to start on the 30th of July, and they're estimating that that trial could run all summer. In fact, it could run into November. So there have been a lot of pretrial motions recently, and the defense has not done real well on their pretrial motions. They have had a bit of a rough time on their pretrial motions. And in fact, this judge was a little critical of Ann Taylor for taking on a second murder case, even while this one is pending and so complex. So, and Lindsay Shiver from the Bahamas is going to be, as far as we know, and it's a little more difficult to pin down dates on her, because the Bahamas doesn't really have the same system that we do. But what we know at this point is her trial is set to start on July 29th. We've also heard that she is involved in yet another criminal case that involves her new boyfriend in Alabama. She's been living in Alabama with her family, apparently with her parents, and apparently she's had this new boyfriend, and there's some sort of domestic violence going on there, some sort of family violence, and he's been arrested. She's a witness, but he said, she said, and are they going to be able to bring in what she's accused of in the Bahamas? I mean, it's pretty complicated, and it's early enough in that case that there's just a lot of uncertainty in it. A lot may depend on what happens in the case in the Bahamas. Frankly, um, if she's going to end up spending lots of time in the Bahamas, they may just opt to dismiss that case. So, um, so Donna Adelson's case has been moved to the 19th of August, and we will wait to see how that one goes. In some ways, it's kind of okay because it was due to start while Karen Reed was still going on. And for those of us that are interested in covering the cases, it's easier knowing that case is going to be bumped out a ways. So, um, so now to Karen Reed. Now, we've had, since we talked, 7 days of testimony, and some of it has been downright spicy. You'll remember that when we were here last time, Jen McCabe was still on the stand, and she was still being cross-examined. That cross-examination actually, and the redirect, took the entire time on Thursday, all day on Thursday, and she finally finished on Friday. So Jen McCabe, for those of you who may not be following the Reed case that closely, is the sister-in-law. Her sister is married to Brian Albert, her sister Nicole. Nicole and Brian Albert are the homeowners of the home where John O'Keefe was found. They were all somewhat friendly with John O'Keefe, and so Jen McCabe, when Karen Reed couldn't find John the next morning, she called Jen McCabe and Carrie Roberts, and the two women got together with her and they went looking for John. And so Jen McCabe was with Karen Reed when they found John on the lawn of 34 Fairview. Brian Albert and Nicole Albert own 34 Fairview, and Nicole and Jen McCabe are sisters. There's so much about this case that is very incestuous. Because it's a small town, everybody knows everybody, and a lot of people grow up there and stay there. So there were a number of people who are, well, I went to high school with this person and I went to high school with that person. And so it's a very complicated, convoluted family tree. The McCabe family is very close knit with the Alberts. And so there's a lot of discussion. The other layer is the fact that they're all law enforcement officers. Some are Canton police officers. John O'Keefe was a Boston cop. Kevin Albert or Brian Albert was a Boston cop. And so Brian Albert's brother Kevin is now a select man. I mean, and they oversee the police. So it's a very connected community, and the Albertson are a very connected family. So interestingly enough, Jen McCabe is only one of two people, is one of only two people who claim that they heard Karen Reed say, "I hit him, I hit him, I hit him." The other person is, hang on, I got to find her name. uh, Katie McLaughlin, and she was an EMT. She also went to high school with a niece of the McCabe family, of the Albert family, sorry. Um, and it may be the Albert's daughter. I I'm I get them all confused. But she went a long way to try and distance herself from the McCabes and the Alberts, and cross-examination showed that they may not have been the closest of friends, but she definitely ran in the same friend group with uh, I think it's Allie McCabe. Um, so the only 2 people, and she was, one of the EMTs that responded that night. So what they're saying is the only 2 people who actually claim that they heard that, um, have reason to be biased and reason. There's no question in anybody's mind that Karen Reed asked repeatedly, "Did I hit him? Could I have hit him?" But that's a far cry from a confession. Um, so that has been a real sort of point of contention. And I think that the defense did a really good job of bringing out how hysterical Karen was. And uh, Carrie Roberts, who was the other woman that was there, said she didn't hear it. It was interesting because originally she went to the district attorney and said that she had heard it, and also said that she had heard Jen say, how Google how long to die in the snow. And under examination, she admitted that she had heard that Jen had said those things, and she had heard, or that Karen had said those things, and she had heard that Karen asked Jen to Google that, but she did not hear it with her own ears. So that's hearsay, and it certainly does not have the same um, weight as it would had she heard it with her own ears. And Alan Jackson, the defense attorney, was able to make the point that she lied to the grand jury, and she finally, after sort of hemming and hawing, had to admit that in fact she was not truthful with the grand jury. So um, after Jen McCabe was done, they called Hannah Knowles. She was one of the forensic scientists that was involved in um, estimating Karen's blood alcohol level. Now, when Karen found John on the lawn and she was hysterical, her parents called the police and said, "We're very concerned that she might hurt herself." So they asked for her to be sectioned, basically. They asked for her to be um, put on a 72-hour hold so her mental health could be assessed. So um, she went to the hospital. In the process of that examination, they drew blood. It was not drawn for the purpose of running blood alcohol. And so later, that blood was then sent out to the crime lab, and they were asked to make extrapolations as to her blood alcohol level. Now, we don't know when her last drink was. We don't know if she went home and drank. We don't know any of those things. And so the defense was able to point up the fact that this was a very unreliable way to get this information, that the information and the process that they went through to get it is kind of fundamentally unreliable. So um, that was uh, where they ended up with her. I don't think that she really helped the Commonwealth, and I don't know that there was really any um, any I don't know that she did a lot of damage to the defense. And that was the end of that day because it took almost all day just to get through Jen McCabe. Then so then we had the weekend. On Monday, the first person they called was Ryan Nagel. Uh, and Ryan's sister, Julie Nagel, was at the house on 34 Fairview. Now, if you remember, um, Nicole and Brian Albert's son, Brian Jr., it seems like everybody in this case is a Brian. We have Brian Higgins and Brian Albert and Brian Logren, who's the snowplow driver, plus Brian Jr. So Brian Albert Jr. was celebrating his birthday. He's in his early 20s. Somebody said they thought it was his 22nd birthday. So they were all the adults, all the parents had been at the waterfall bar, and everybody got invited back to 34 Fairview, and Brian Jr. and several of his friends were at the house celebrating his birthday. So they all went back over to the house. Brian Albert and Nicole Albert said, "Stick around, it's almost midnight and it's going to be his birthday." So everybody stayed around to celebrate his birthday at midnight. Karen Reed and John O'Keefe had not arrived there yet. They were some of the last to arrive. So, but Julie Nagel was a friend of Brian Jr.'s, and she was there at the house celebrating his birthday with him and several other people. So she didn't have a ride home, and her brother, Ryan, and his girlfriend, Heather Maxon, and another friend who was the driver, went over to 34 Fairview to pick Julie Nagel up. And when they pulled up in front and texted her, and she said she was having a lot of fun, and Jen McCabe had said, "Oh, we can take you home." So she told Ryan Nagel that she didn't need a ride and that she would be going home with Jen McCabe, Jen and Matt McCabe. So, but when they pulled up in front of the house, they pulled up behind Karen Reed's car, and they saw only her in the car. She was in the driver's side of the car. And they waited until they heard from Julie that she didn't need a ride, and then they drove away. But in the meantime, they were parked behind Karen's car. The timeline in this case is so critical and so keeps shifting. But if you believe the cell phone data, the Commonwealth cell phone experts believe that the collision or whatever happened to John O'Keefe happened at 12:31, because after that his phone didn't move. However, there's also an indication that after that he actually manually locked his phone, or somebody manually locked his phone. We also know that it's at least a 10-minute drive from 34 Fairview to One Meadows, which is where John O'Keefe lived and where Karen Reed went that night after she left. And she clocks in at having connected her phone connected to the Wi-Fi at One Meadows at 12:36. So if it takes 10 minutes at least, and that would be not even considering the fact that it was snowing and there was a blizzard kicking up. So But uh, it's hard to figure out how she could hit John O'Keefe somewhere around 12:31 or 12:32 and connect to the Wi-Fi at One Meadows at 12:36. There's just not enough time for her to have driven that back to his house. So the next witness then was Heather Maxon. She was Ryan's girlfriend, now his ex, at the time, and was in the truck with he and his friend when they went to get Julie. She said she'd had a lot to drink. She wasn't really paying a lot of attention, but she did corroborate Ryan's story about seeing a woman, behind the wheel of her car with her hands on the steering wheel, um, and seeing no one in the passenger seat. So, um, and let me see. That was the day we also had Katie McLaughlin, who was the EMT who claims to have heard, I hit him, I hit him, I hit him. And also Sarah Levinson, who was one of the other friends that was at the house at one of Brian Albert Jr.'s friends that was at the party. Um, and the last person they had was Lieutenant Kevin O'Hara. Now, there's one thing about this case that's always been very confusing to everyone, and that is that they didn't call crime scene experts to the property to handle the crime scene. Okay. They didn't call anybody from the crime scene processing team to process the scene. Instead, they called the search team. So most sheriff's offices, most or police forces have a search and rescue team. We have one here. My husband was a volunteer with the search and rescue organization in Central Oregon for 16 or 17 years. They have a really different mission. Their mission is to go out and find people who are lost. That is their primary mission. And they sometimes participate in evidence searches, but they're never the primary search teams, and they're never the primary people who would do evidence collection. Typically, what happens is if they're doing an evidence search, if they come across what they believe is a piece of evidence, they simply either flag it with a flag or call somebody over and say, I think I found something. They're not they're not law enforcement tasked with the purpose of collecting evidence like a CSI unit would. They're not trained as crime scene investigation experts. So it was very strange that they were called and the crime scene folks were not called. So this Lieutenant Kevin O'Hara is the senior guy in charge of the search and rescue organization. And, he talks about how they did an evidence search. They walked shoulder to shoulder and they had rakes and they raked through the snow and they found a few pieces of taillight. This was a few days after, and it also was, well, it was actually the evening because they had to use headlamps. They were there after dark, the evening after John O'Keefe was found. And it was also after her car was impounded and taken to the Sallyport County Police, which leads us to the rest of the information. So one of the things we've learned is that when a when a case becomes a homicide, by statute, it has to be referred to the Massachusetts State Police. That local law enforcement doesn't investigate their own murders. So, one of the first people from the Massachusetts State Police the first one to be called was Connor Keefe, and he was called today. So I want to go back through what happened yesterday, because there were a couple of interesting witnesses, the first of whom was Lieutenant Paul Gallagher. He was the head of the detective unit at some point, was promoted to that and then retired. But at the time, he was a detective on the Canton Police Department. So he is the guy who is responsible for the red Solo cups and the Stop and Shop bag and the snowblower. So when they initially alerted um, Massachusetts State Police, keep wanting to say OSP for Oregon, MSP, um, they didn't respond and said they weren't going to respond out to the call because John O'Keefe hadn't been pronounced dead yet. He'd been taken to the hospital and it didn't look good, but there wasn't a pronouncement of death. So Gallagher was the ranking officer on the scene. So he was pretty much at the time in charge of the investigation initially. He's the one who decided to go home and get his leaf blower and use his leaf blower to blow the snow away in order to look for evidence. Now, Robert Alessi brought out a lot, I think it was Alessi, brought out on Cross that although he thought it was a very effective way, it certainly lent itself to a lot of contamination, including contamination from the gas-powered engine, exhaust, and contamination from whatever else may have been in the crime scene. He identified 6 spots of blood, which he then went across the street to the deputy chief's home. The deputy chief of police lived directly across the street from the Alberts. He went across the street to the deputy chief's home and brought back Solo cups, red Solo cups. They were not sterile. There was no way of knowing whether they'd been used or not, whether they'd been washed or not. But he brought them back and they collected the blood and in clumps of snow and put it in those cups. Then they didn't have an evidence bag, so they used a Stop and Shop bag. We have absolutely no idea what else had been in that Stop and Shop bag. At one point, there was some indication that within the DNA, there was pig DNA. So everybody started speculating whether or not somebody had bought ribs or something and used that grocery bag, because the Stop and Shop is a grocery. So Alan Jackson kind of made mincemeat of him over the handling of the evidence. And the other thing that he questioned was why nobody went in the house. So one of the weirdest parts about this is Brian Albert, who is a 30-year Boston cop, who is a trained first responder. He never responds to this big commotion on his lawn. Karen Reed's running around screaming hysterically. Carrie Roberts is screaming at her to shut the F up. There's police radios and there's people talking and there's this huge commotion going on out on the lawn. Nobody from the house ever comes out. No lights come on, nothing. Now, one thing that's curious is that Jen McCabe claims that it wasn't until somebody sent her into the house that she woke them up to tell them what was going on. They still never came out of the house. And two things are interesting about that. Jen McCabe testified that she never saw the dog, that the dog didn't bark when she came in. It wasn't in their bedroom where it typically slept. The dog was nowhere to be found. There were other people later who were there. Gallagher, when he went in the house, said he didn't see a dog either. So that's suspicious. I think they got that dog out of there post haste. But so Brian Albert and Nicole Albert claim that they didn't know anything was going on until until Jen McCabe came in and woke them up. So, and that was like 6:30, between 6:30 and 7 a.m. But Jen McCabe's phone shows that at 5:07 that morning, she had a 38-minute call with her sister. Now, that call doesn't show that it was a missed call or that it was a refused call, but she absolutely claims that she did not talk to her sister at 5:07. So that is still a little bit of a mystery. I'm sure that that's going to continue to come up. Really, the upshot of this was, 38 seconds. Yeah. Really, the takeaways from this Gallagher was, first of all, that it was an incredibly shoddy investigation, and that it was really a poorly managed. The other thing that takeaway is that although Gallagher said that Canton had recused themselves from the case because of their connection with everybody, they really didn't. They recused themselves from the interviews, but they didn't necessarily recuse themselves from the investigation completely. They were involved in collecting information, and they were involved in Gallagher was actually at the Sally Port when Karen's car was brought in. So very clear that that they continued to be involved. Gallagher is also very close personal friends with Brian Higgins. Now, anybody who's new to this case, Brian Higgins is an ATF officer, a federal alcohol, tobacco, and firearms officer. But he had offices in the Canton Police Department, and he and Lieutenant Gallagher were close personal friends. Brian Higgins was also friendly with the Alberts. So there were all those connections as well. But it's very evident that although they said from the beginning, we have to bow out of this because there's too many conflicts, and it's a Massachusetts State Police case because it's a homicide. So even though they said that, there's not much evidence that there's a lot of evidence that they were continued to be involved, at least on the periphery. It was actually Gallagher who went into, when the crime lab, the MSP crime lab, came to get those solo cup samples, it was Gallagher who went into the temporary evidence fridge and brought them out. He had access to the temporary evidence locker, as well as a lot of other people at Canton PD. So, I mean, there was a very sloppy chain of custody about those, where those samples were, who handled them, and all in all, a pretty shoddy investigation. So, So today we had Connor Keefe. He's a young Massachusetts state cop, and you could tell that Michael Proctor's name came up over and over again. Proctor is the disgraced Massachusetts state police officer who was the trooper who was the investigating officer on this case as well as on many others. He was on Sandra Birchmore, and he's also been on Brian Walsh. So his conduct and his evident bias in this case got him fired from the Massachusetts State Police, which is pretty hard to do. So because of his police misconduct, he was fired. So they called Connor Keefe, and they were able to question him about a few things. He was the one who went and got the video footage from the waterfall bar, from Ring Camera. I think he went around and collected up evidence, but he's not the one who did the analysis. Michael Proctor did. At one point, they asked him about an interview that he attended with Proctor, interviewing Sarah Levinson. She was one of the friends that was at Brian Albert Jr.'s birthday party, was at 34 Fairview. And so they asked him about that. The defense asked him about that, if he was with Proctor when he interviewed Sarah Levinson. He initially said, "No, I wasn't." They presented him with the report, Proctor's police report, and after studying it for quite a long time, they asked him again, "Does that refresh your memory?" And he said, "Yes." And they said, "Were you there?" And he said, "Yes." But a lot of people have wondered whether or not Proctor was going against policy and interviewing witnesses without a second officer there, and whether or not Connor Keefe was really there. So the whole thing looked fishy. His body language was very tense. It was, yeah, if you get a chance to watch that portion, you can see he was very uncomfortable with the questions the defense was asking. And then the final witness for so far for today was Jessica Hyde, and she is the cell phone expert that the Commonwealth has called. They called Ian Whiffen earlier, and now they've called her. Both of them agree to this idea that there is question about when Jennifer McCabe made a Google search. The Google search timestamp is at 2:27. She Googles how long to die in the cold, and a couple of different misspelled permutations. They contend that Jennifer McCabe says that Karen Reed told her to Google that at 6:27, I think, or 6:30 something, while after they'd found John. So there's a dispute about when that search was made. If it was made at 2:27, as the defense claims, and as the original records showed, it's kind of game over. I mean, it shows that there was some sort of collusion going on to cover up John's death. However, the prosecution witnesses, the Commonwealth's witnesses, claim that what happens when you open a tab on your phone, a Google tab, is that even if you make a search on that, you open the Google tab and then hours later you make a search, it's going to show when you opened the Google tab and not actually when you made the search. Now, to be honest, that doesn't make much sense to me. I think that's kind of crazy, but they're absolutely, both Jessica Hyde and Ian Whiffen are absolutely, to a um, scientific certainty, convinced that that search was actually done at 6:30 in the morning, and it just referred back to that earlier tab that she'd had open. Um, there, it really is a battle of the experts. The defense has a very well-known cell phone expert who's going to come in and say that's bunk. Ian Whiffen, the first cell phone expert, is actually an employee of Cellbrite, which is the program, one of the main programs that they use to extract phone data. And since this happened, it's only come up twice, and in once here and once in Germany. And because of that, Cellbrite has now changed their search parameters so they don't put those timestamps in anymore because they claim they're unreliable. Now, Jessica Hyde was on the stand for most of the day, and it was a very detailed and very technical cross. I honestly don't know how much the jury got out of it because it was so hyper technical. And, they're talking about hash values and PDFs and this and that. And I know that Robert Alessi, who was the person who did the cross examination, and he is the one who crosses a lot of their experts. He's really the technical guy. I know that he does a fairly decent job of making it, didn't want to say dumbing down, making it understandable for the lay person. But still, it's a very complex issue. It's a very complicated issue because cell phones, like computers, they're the way that they file data is so foreign. I mean, when we get on our computers and we're looking for a file, right? And we have the picture of the file folder. We think, okay, everything I need is in that file, but it's really not. It's in different places all over the computer's hard drive. And so that means that sometimes things are written in one place at one time and then they're written someplace else at another. And it's a very complicated analysis and a very complicated, almost like mapping, of the timeline. Even that single search um, takes mapping the timeline of when it got written to where. And so it's a very convoluted science, and it makes for really dense, difficult testimony. So it's hard to say at this point. The jury's heard from two different cell phone experts, and both of those, and one on data location, on GPS location. I think that Robert Alessi did a really good job with the GPS location guy of really being able to bring that back to things that the jury would be able to understand, and using this guy's own um, PowerPoint display to say, yes, but it actually, the phone could have been anywhere within this circle. And so, I mean, I think Alessi did a good job with that one. I think he did okay with it with Ian Whiffen as well. But I think that the jury may be getting a little tired and their eyes may be glazing over already with all of this technical cell phone data. And that challenge for lawyers is going to get nothing but worse. Every one of these cases these high profile cases we're seeing, Lori Vallow's case was 5 terabytes. Then Donna Adelson's case was 40 terabytes. And I mean, it's just like the digital data and the electronic data, it just grows exponentially in every one of these cases. I mean, in the Adelson case, we're talking about 30,000 data files, emails and text messages, and 30,000. So, it really is, every one of these cases is getting more and more complex and more dense in the amount of evidence that's coming out of devices, whether it's GPS data, whether it's location data, whether it's text, emails, when you logged on and off of the internet, when you connected to Wi-Fi, when you connected to your vehicle, uh, the computer in your vehicle. I mean, there's just so much that it's really going to be overwhelming, and we're going to see, I think in the next couple of years, we're going to see more and more companies being formed for the sole purpose, and they're going to be a mix of software people and paralegals, and they're going their sole purpose is going to be to manage discovery. And I think more and more we're going to see organizations having to hire discovery clerks. One of the things that the judge in the Koberger case criticized Ann Taylor for was the fact that haven't hired someone to manage their discovery. And I said from the beginning that that was a big mistake in the Vallow-Daybell case. They needed somebody whose only job was to keep track of and to manage discovery. I guarantee that in Karen Reed's case, one of those people on the team does nothing but manage discovery, primarily the digital discovery. So, and I mean, they're fortunate. They not only have Karen Reed not only has the wherewithal to hire a really high powered team, but they also have a whole group of volunteer law students that are there that are helping out with the case. So they've got a little bit of free labor to toil in the salt mines of sorting and reviewing discovery. So once again, you kind of stand there and shake your head and say, the state's got a huge advantage because they have nearly unlimited resources and most defendants don't. Karen Reed has decimated her life and ruined her. She has sold her house. She has uh, cleared out her retirement funds, and she is still $5 million in debt to her lawyers. A lot of the lawyers have said that they are working pro bono on the case. Robert Alessi gets $1,300 an hour, is working pro bono. So, I mean, she's been able to cobble together enough money and enough talent to be able to put together a whale of a team, but that's not the norm. More often than not, you have public defenders who are struggling to get funding. So the judge in the Koberger case told Ann Taylor that she needed to go back to the judge in Idaho that approves or disapproves the um, public defender expenditures and ask that judge for more money to to go through discovery because they got another big dump of discovery, and they were kind of angling for a continuance, and the judge said it's not going to happen. Um, the July date's the July date. So if you need more people, you need to go back to judge whoever he is and tell him you need more money to hire people. So hopefully she will be able to get enough help to be able to go through those. Now, I will say that in that hearing, in the Kohberger hearing, Ann Taylor also said, it is my process that I look at every piece of discovery. And, you know, being a lawyer and having done trial preparation, I totally understand that. I mean, in an ideal world, the lawyer would look at every piece of discovery. But when you are talking about terabytes, every terabyte is supposedly like 100 reams of paper if you were to put it on paper. I mean, it's just an incredible amount of data. There's no way that Ann Taylor is going to be able to do that. I mean, there are hours and hours of video footage from every ring cam and traffic cam all over Moscow. Now, is any of it relevant? Is any of it actually directly related to the case? Probably not. I mean, if there might be 1% of that information that's actually relevant to Brian Kohberger. And it's not a great use of her time for her to be going through every piece of that extraneous information. So, you know, more and more we're having to rely on assistants, paralegals, law students, associates who are able to do the grunt work, for lack of a better term, you know, to do the routine just sorting. And I mean, one of the things that we've talked about before that happens is there are always duplicates. So if you get a, a box of discovery or a file of discovery, probably half of it is going to duplicate stuff you've already looked at and seen before. And that's often because let's use Vallow as an example. You had Gilbert Police and you had Chandler Police, and they were sharing information. You also had Idaho, you also had the FBI, but with the Arizona case, you had Gilbert Police and Chandler Police sharing their information. You also had an ongoing investigation. So what would happen is Gilbert would send Chandler something, and then Chandler would send Gilbert something, but it would be a duplicate of something they already had. And so the duplicates just piled up. And then every time a police officer writes a supplemental report, for example, you have, you have one main report into Charles Vallow's death. And then you have an officer that goes out and gets the camera footage from CVS. Well, that officer writes a report and says, I went on this date and this time and I found this in the CVS's file and I'm attaching it or I'm putting it into evidence. So when that supplemental report gets written, then the law enforcement agency sends the original report plus the supplemental to the prosecutor, and they discover the whole thing to the defense. So now the defense has two copies of the main police report. And that happens for every supplemental report. And there could be 20 supplemental reports on a murder case. So you end up having somebody who's just literally wading through, yep, seen that, yep, seen that, yep, seen that, just through all of the duplicate discovery. So it's challenging, and it's not going to get any better. It is going to get worse, because every case now really turns on the digital information. And until technology changes or something else changes, that's going to be the lot of a defense attorney is just plowing through these hours and hours and hours of discovery. So, um, it's a daunting task, and it's just gonna get worse. And I think we are going to see more and more, um, defense attorneys asking for extra money for someone to manage discovery. And I think we are going to see private companies coming online that are going to be contracting with prosecution or defense to do the administrative work of managing discovery. And then you get into the question of, well, i- is that secure? Does that violate someone's privacy? Does that violate the attorney-client privilege? Is it necessary for us to bring somebody in-house to protect the client's rights? So, I mean, there's a lot of thorny questions coming along about that. I was reading in my state bar publication a couple of months ago, where these very issues were coming up, and just digital security, storage security, whether or not your files in your office are secure, and then who gets the opportunity to look at them. We saw that in Delphi, and we saw what happened in Delphi, which was very unfortunate. In Richard Allen's case, his lawyers had a room that was their war room, that was their repository for all of the discovery in the Allen case, and it was where they worked on it. One of the lawyer's acquaintances who had shared office space and been in that office before, came into the office. The lawyer was on a phone call. The guy was sort of wandering around unsupervised. He went into that room and took pictures of some of the scene photos in that case. And he shared them with someone else who ultimately shared them with a couple of um, YouTube providers. And it was a whole big mess. So ultimately, one of the people who was down the line in the string of sharing the information was so upset about it that he took his own life. And it was a very unfortunate situation. So, we're constantly talking about how do we protect our clients' privacy? How do we protect the victim's privacy? How do we make sure that the attorney-client privilege is protected? And all those are questions. Every time we get new technology, we have to go back and reassess that all over again. Um, and as it's funny because the law is always very slow to change. Um, and so this is an area where the state bar associations and the professional liability organizations, the insurance companies are all tapping their feet and saying, tick, tick, you guys better have some guidelines and you all better have some, you better stay up to date on technology and what technology can do. So, yeah, it's just going to continue to be like a tidal wave. Hi, Mary. I haven't seen you in a bit. I think you were in the chat last week. It's nice to see your name, and I would love to address this. Yes, attorneys can use AI. Early on, an attorney got caught asking AI to draft pleadings from scratch, to draft a motion. And the AI made up cases to cite. And the attorney filed it as it had come from AI. And it was very quickly discovered that the cases that the motion was citing didn't exist. and the attorney got called on the carpet. Here's the thing. Ultimately, the attorney is always responsible. Responsible if your paralegal gets stuff wrong, responsible if your administrative assistant gets things wrong. Ultimately, the buck always stops with the lawyer, and it is their ultimate responsibility to supervise whether it is their employees or whether it is their bot. So, yes, lawyers can use AI, but when you use AI, you have to check and double check to make sure that the information that you're getting from AI is accurate. I would never use AI to draft pleadings. That would be, I think, crazy. But the places where AI can be really helpful is you can plug the parameters into AI for what you are looking for, say, in terabytes of discovery, and you can form those parameters to the point where AI can flag those things as things that you might want to look at. Again, it's only going to be as good as the search parameters you put in. But if you make it narrow enough to get what you want, but maybe broad enough so it may bring in some unnecessary stuff, you have reduced the pool of things that you have to look at um, to be much lower. There are several companies out there who are or have written AI platforms for organizing and searching discovery. Um, they're being used a lot more commonly in civil cases than in criminal cases, but there are some criminal attorneys who are beginning to dabble in AI because of these huge volumes of digital information. So that's a really good question. AI is, I mean, the bar associations are looking at it as a tool just like any other tool, whether it's your fax machine, whether it's your email, whether any of those things. AI is just another tool. The lawyer is still ultimately responsible for the accuracy and the truth of what's being said. The lawyer still has the ultimate obligation to be truthful with the tribunal. Clearly, filing motions and citing cases that don't exist is not being truthful with the tribunal, and that was very concerning. So, a lot of bar associations are creating guidelines and they have a lot of committees that are looking at the issues and trying to come up with ways to use technology in a way that's going to be helpful without sacrificing accuracy or without sacrificing a lawyer's obligation for truthfulness to the court. So that's a great question. I think we're about ready to take questions. So let's see what y'all have for me. Jackie Dodson, in the Adelson case, she has apparently been using other inmate PIN numbers to call her husband, hence the wiretaps, probably on his phone so they can hear the calls and learn whose PIN she uses. Yeah, Donna Adelson ain't stupid. And she knows that the phone calls that she had with Charlie when he was first in jail were recorded because they were recorded on Charlie's end. He was initially in jail. She also knows that the calls that she was having were recorded as well. Um, I understand that inmates do use one another's pins, although they're not supposed to, and it could result in discipline within the jail. We saw that recently with Stephen Stearns in the Madeline Soto case. He was disciplined for using somebody else's pin. Um, Nonetheless, all jail calls are recorded. But I could see where they would want to tap Harvey's phone so that they would get them from his end, no matter whose pin she was using from the jail. I also wonder about whether or not uh, Wendy is having conversations with Harvey. She knows that um, that the conversations she has with her mother are recorded, but she may have thought she was dodging a bullet by having her conversations with Harvey. So yeah, I think there's more to be revealed in the Adelson case. It seems to be the case that just keeps on giving. So it will be really interesting. There's that word again, interesting. My husband's always saying I overuse it, but musicer 51. This trial is new to me, and I've been watching the trial. I'm confused about what each side is trying to convey. I've heard no evidence that shows either guilt or innocence. If you're talking about the Reed case, it is a really complicated case. It took 10 weeks last time. I think it's going to take every bit of 10 weeks this time. So essentially, the story is a bunch of people, some of whom were Canton police officers and some of whom were Boston police officers, got together to socialize. After they had been at this place called the Waterfall Bar and Grill, listening to music and drinking, when the waterfall closed somewhere around midnight, they all decided to adjourn to Brian Albert's home. He was a Boston cop. John O'Keefe was a Boston cop. And they decided they were all going to go back over to the Albert house because the Albert's 20-something son was celebrating his birthday, and there was already kind of a party going on there. So they all went back to the Albert house. John O'Keefe and Karen Reed, boyfriend and girlfriend. John O'Keefe had a young niece and nephew that he was a guardian of. Their parents had died. And Karen Reed was often involved in helping take care of them. So they left the Waterfall Bar and Grill. They pulled up outside of 34 Fairview, which was Brian Albert's house. And that's where everything gets really murky because Karen left without John. She says she dropped him off. She left without John. She went back to John's house. So they didn't live together, but she went back to John's house and kept trying to call him. Where are you? She was concerned about leaving the children, although they were young teens, overnight without an adult there. So she stayed. He didn't come home. It was very unlike him. And so finally at, I don't know, 5 o'clock in the morning, she started calling people trying to figure out where John was. Ultimately, she and two other women who were in that circle of friends drove back over to the house on 34 Fairview, and Karen Reed saw him lying in the snow in the yard in front of the house. It was bitterly cold. The low was 15, the high was 29, and there was a blizzard blowing up. Although at the time his body was found, there was only less than an inch of snow on the ground. He wasn't buried in snow. But later that day, 12 inches of snow fell. So it really was a blizzard. So the Commonwealth claims that Karen Reed was angry, either angrily or accidentally backed over into John O'Keefe and knocked him down and then left him. The physical evidence, certainly everything that we heard in the first trial, is that the physical evidence doesn't support that. But see, we haven't gotten to any of that yet. I mean, we're just scratching the surface. This is middle of the second week. we're really just scratching the surface, because the physical evidence that we heard at the last trial from the accident reconstruction experts and the autopsies make no sense. If John O'Keefe had been backed into by a car going 20 plus miles an hour in reverse, he would have had injuries to the lower part of his body. He has no lower extremity injuries. The only injuries are cuts and abrasions and perforations on one arm, and all of his other injuries are above the neck. That makes no sense. The defense claims that there was potentially a couple of reasons why John O'Keefe might have gotten into it with somebody in the house. One, Colin Albert, who was the nephew of Nicole and Brian Albert, was something of a mouthy teenager. And he and John O'Keefe had words more than once. John O'Keefe was kind of a fusspot, didn't like anybody in his yard, didn't like anybody, and the kids cut through his yard all the time. The one kid, when he told them not to cut through his yard anymore, they started throwing trash in his yard and beer cans and what have you. I mean, it was a little bit a feud at that point. And Colin Albert was known to be kind of hot-headed and to get in fights. So there's that. There also was a suggestion of a flirtation between Karen Reed and Brian Higgins, the ATF agent, who was friends with everybody. There was some indication that he was very interested in her. She was sort of, maybe playing him along a little bit, and that he was angry when John and Karen came into the waterfall together and they were so lovey-dovey. So, couple of motives. So the defense believes that John O'Keefe, in fact, did go in the house and that he got into an altercation in the house. They believe that the injuries that were inflicted on his arm came from the family dog, who was a very large female German Shepherd, who may or may not have been a police dog training washout. So we know the dog wasn't good with strangers. We know that she wasn't particularly a friendly family dog. And the testimony we're hearing now is that nobody's seen the dog. We know that after this incident happened, the Alberts sold their home, which was the home Brian Albert grew up in and had lived in for 40 years. Before that, they jackhammered up the concrete floor in the basement and replaced all the flooring in the basement, and they rehomed the dog that had been with them for 6 years. So it was, there's a lot of sort of suspicious stuff that happened as a result of, that kind of sounds like consciousness of guilt. So the Commonwealth claims that Karen Reed was drunk and angry and backed into John O'Keefe. The defense claims that the injuries are not consistent with him being hit by a car, and that in fact he was the victim of a fight, and then they pulled him out and threw him on the front lawn, perhaps not knowing how badly injured he was. We are going to hear from medical examiners. We're going to hear from brain injury specialists. We're going to hear from a lot more people. I'm so sorry. We're going to hear from a lot more people about John O'Keefe's condition and about the physics of whether or not Karen could have hit him. One of the issues is, thank you, Jackie, Um, one of the issues is that Karen O'Keefe had a broken tail light. Now, when there's Ring camera footage at John O'Keefe told her, because this big blizzard was coming, to park in his garage. She wasn't used to it, and it was a pretty tight fit. When she backed out of the garage, she turned and there's Ring camera footage of her backing into John O'Keefe's car that was in the driveway, his SUV. And her and there are other witnesses that say after she did that, she said, "Oh my gosh, I cracked my tail light because I backed into John's car." She was so upset. But the Commonwealth claims um, that the tail light was broken when she hit John O'Keefe. After the incident, Karen Reed initially went to John's house. His parents were there after they had pronounced John deceased. And she felt really uncomfortable there. They were not happy to see her. And she left. She went to her parents' home, which was close by. And later that day, they got a warrant and seized her car. After they seized it, they took it to the Canton Police Department. And the Canton Police Department, even though they had said, all these people are law enforcement, we think we should not be involved in this case, and recused themselves, semi-recused themselves, they were all around. And then the Massachusetts State Police came. The problem is that there are no photographs of the car when it got to the Canton Police Department's Sallyport, which is their garage. Um, no photos of that tail light until after, and suddenly pieces of that tail light start showing up in the lawn at 34 Fairview hours after that. So there's a lot of suspicion that there's some level of corruption and collusion um, within the department, because law enforcement protects each other. So that really is kind of the crux of the case if you are new to it. Um, I will tell you that if you are new to the case, there are a couple of other creators that have a lot in their archives and in their past shows about the case. Attorney Melanie Little is one who has been following this case since very early on. She's a retired New York attorney. She did primarily civil work, but she has been covering and following this case very closely for quite a while. And she has a library of information about the case, and has been, I mean, she probably knows more about the case than the prosecutor's forgotten. So she's probably forgotten more about the case than the prosecutor knows. That's what I meant to say. So, other questions? No, I am not reverse aging. I just saw that comment. And no, I am not. Thank you so much for being sweet to me and telling me I look good, but I am definitely not reverse aging. Look at this neck. Hey, the big 7-0 is coming up next year for me. So I am not in any way reverse aging, but thank you. Hi, Rachel. What's most bothersome to me about the 2 a.m., 6 a.m. Google search? If Jen McCabe is telling the truth, what does that mean for reliability for other people convicted with cell phones? That's exactly the issue. Um, if in fact other people have been convicted based on cell phone searches, and the one that comes to mind is Brian Walsh, because one of the most damning bits of evidence for him is the fact that he Googled a bunch of very explicit and damning Google searches about things like hiding a body and, how to dismember a body. And so, eh, and Proctor was on his case. And now we've got this issue of whether or not Google searches happen at the time they actually say they are. So I do think that it's going to be an issue. And I do think there are lawyers out there that are watching this very closely and are going to start saying, maybe I had better revisit some of these cases that turned on Google searches. Um, so we'll wait to see. The other interesting thing is that not all of the platforms, the analysis platforms like Celebrite agree. So a couple of the other search tools, I guess you'd call them, for cell phones, parse that data differently. So that's been another point of contention, that not all of the experts, not all of the people who are building the software even agree with how that data is um, it is to be read. So although Cellbrite has stopped reporting the times on Google searches, the other ones haven't. So yeah, and it's an evolving science. Um, uh, for every time, they were talking about the today in the Reed trial updates. How often does Cellbrite update? At least once a month, sometimes more, because they update every time an application updates, every time a phone updates, every time there's a software update for your phone, every time Instagram updates or any of those apps that people use all the time. Anytime Snapchat updates, they have to issue an update too because they've got to stay ahead of of the technology. So it's absolutely a just quickly developing science, and that's not something the law is good at. I mean, I always say one of the things about Roe versus Wade, and I don't want to get into the politics of it, but in 1963, when Roe versus Wade was first decided, the the issue was the medical profession broke down a pregnancy into 3 trimesters, and the issue was when was at what point was a fetus viable. So initially, that was 3rd trimester. So when the Supreme Court came down and said 1st trimester women have have a right, 2nd trimester they and their doctors should be making the choice, 3rd trimester the unborn child has rights. And so they sort of drew that line. Well, as technology improved, the viability of a fetus keeps moving back. Babies that are born in the early 20-week range are prematurely are surviving with huge interventions. But so the law doesn't catch up with science very quickly. We're still dealing with Daubert hearings that happened 20 years ago, and case law on scientific and expert opinions from 20 years ago. We just the law doesn't turn on a dime, and we're just constantly in that conflict between the technology changing so fast and the law changing so bloody slow. So it's just going to be an evolution much faster than probably the law is comfortable with, but much slower than technology is moving. So, yeah, good question. I'm wondering if the defense will call Proctor to try and show the incompetence. Absolutely. I don't, first of all, I don't know how the prosecution gets by not calling Proctor. If they don't, the defense will absolutely call him. But I guarantee you that, that if the prosecution calls him, the defense is gonna skewer him. I mean, he's ugh, that I would not wanna be him. I didn't wanna be him from the last trial, and that was before his own organization found that he'd been biased in this case, as well as all of his inappropriate, text messages and communication. The bigger deal is that they actually found that, that he had violated his responsibility, to be a neutral fact finder, and that he was clearly biased. And that he would have should have, it was required to have recused himself, and he didn't. So, I think he did a lot more funny business than even than we know of. But at this point, it's going to be really hard to tell what kind of funny business he did because they're so quick to throw him under the bus, too. So when the whole issue came up of how come we didn't get the videos out of the Sallyport, the garage where Karen Reed's case was, where Karen Reed's car was, and then they came in and they were reversed, um, and all of that stuff came up. The first thing they did was say, "Oh, well, Proctor had those and they were in his file and we couldn't discover them because Proctor didn't give them to us." So they're all going to be really quick to throw Proctor under the bus. And we'll see. Incidentally, Proctor is a very old Massachusetts name that goes back to the Salem witch trials. There were proctors that were accused of being witches back in the during the Salem witch trials. And in fact, if you've ever been forced to read The Crucible or ever seen the play done, one of the characters is Goody Proctor. Um, Back then, they used the word Goody instead of Mrs. So she was, yeah. Um, Hi, Jane Blackbird. I'm bothered by Karen Reed's BAC being used, though she wasn't driving a vehicle, driving a bike, or walking. How can they use that against her so many hours after the event? Well, first of all, I think that the data is incredibly unreliable, and I think that the defense has done a really good job of pointing out the unreliability, the fact that it was drawn in the hospital, that they spun it into serum, that they were using it. The hospital didn't draw it for the purpose of doing BAC uh, calculations. And that the state police lab then took the results that the hospital got and extrapolated them. And they used a lot of assumptions, including when her last drink was. Um, and nobody really knows for sure when her last drink was. She could easily have gone home and done shots of tequila after she got home. She was mad. I mean, who knows? So, it was under very unreliable circumstances. Her blood alcohol level would never have stood up in a DUI case. So, I I I think that the Commonwealth has made a mistake from the beginning in really going down that road and introducing that. But they needed it in order to get in the one of the charges being a motor vehicle collision with alcohol. So, I mean, it's the least serious of the charges, but uh, they needed it in order to make that charge stick. This is a good question. We don't know. What we know is that the federal government and the FBI were investigating the investigation. They were investigating Proctor and the Canton Police Department and Brian Albert and all of those folks. That was the reason the feds got involved. The FBI was investigating, and the Attorney General was in, and the Justice Department were involved because they were police officers. We don't know. So the only two things we know is that the FBI originally hired the ARCA experts, Dr. Wolf and Dr. Rentschler, to do an accident reconstruction on the accident. And they were subpoenaed and came to court. Initially, Karen Reed's defense team reached out to them. So when the federal government has a parallel investigation going, they do not have to release any of their information. But the Commonwealth requested through what's called a TUI letter, all of that information, and they turned it over. The feds turned it over to the prosecution. So the prosecution had to discover it to the defense. When the defense got it and they realized how favorable it was to the defense, they reached out to the ARCA experts and said, will you come and testify about all this testing you've already done? And will you come and testify on Karen Reed's behalf? Initially, the ARCA experts said, sure, we'll send you a retainer agreement and here's what it costs. Then they decided that before they did that, they needed to clear it with the federal government because the feds had sealed some of their information. So they reached out to the feds and the feds said, you can't. So it wasn't until later the feds said, okay, you can have the ARCA experts and you can use everything that we've discovered through the TUI letter so far, and they can testify to whatever is in their report, but you can't hire them to come and do additional testing, and you can't use anything that's in our sealed files. So they called the ARCA experts in the first trial, and the judge had them come in and they did a lengthy voir dire on them. They were qualified as experts and they came in and they testified at the first trial. They were not allowed, the defense was not allowed to say these folks were hired by the FBI. They could say they were not hired by us, they were hired by a different agency, but that left it hanging for the jury. And in the jury interviews post-trial, some of the jurors said, well, we just discounted that because we figured that it was either her insurance company or maybe it was one of her followers that hired this group. That was unfortunate because the ARCA witnesses were very persuasive. So after that, they got a bill from ARCA for their travel and expenses. And so they called the Department of Justice and said, can we even pay this? And the Department of Justice said, yeah, you can pay it. And then the Department of Justice said, you can use the ARCA witnesses. So as trial number 2 rolled around, they've had the ARCA witnesses do some additional testing. And that is still, it's still a bone of contention between the prosecution and the defense. The prosecution's just utterly convinced that the defense has been colluding with ARCA all along. So that was a long discussion of the Fed's investigation. So shortly before this trial started, and around the time that the Department of Justice gave the defense the green light to use the ARCA witnesses, Canton Chief of Police Helena Rafferty came out and announced that the feds had closed their investigation and that they were not bringing down any indictments. Nobody has been able to confirm that because the feds don't confirm those sorts of things. So no one has been able to tell for certain whether what Helena Rafferty said is true or not. We know that the feds allowed the defense to hire the ARCA witnesses, the accident reconstructionists, and we also know that that but we also know that they did not allow any release of their sealed information, their sealed documents. So we really don't know. The defense was able to get transcripts of the federal grand jury, the witnesses that testified at the federal grand jury, and have been able to use a little bit of that for impeachment. They definitely impeached Carrie Roberts with her testimony at the federal grand jury. So the answer is nobody's really sure. There are some things that point to the investigation wrapping up, but nothing definitive. So, good questions. Rachel, part 1. Discovery ID stated in an article that Karen Reed's defense team approached them before the first trial for behind the scenes access. Okay. Because so many of those clips are being used in this trial, and in my humble opinion, are the worst evidence against Karen Reed if she's found guilty, is that ineffective assistance of counsel? I don't think that it's ineffective assistance of counsel. I do think it was really ill-advised. I think that at the time, Karen Reed really wanted to tell her story. And I think that they believed that, for better or worse, the trial was going to be over long before that aired. Any of those interviews aired, and that turned out not to be the case. The clips that I have seen, I kind of, at worst, they're kind of neutral. I didn't really think those clips are as damning as I think the Commonwealth thinks they are. So I don't know. I didn't find them terribly inculpatory. I didn't find there to be really any point that she was confessing or acting like consciousness of guilt, which is what the Commonwealth tried to say, is that these prove consciousness of guilt. Oh, I just think that's malarkey. I don't think it does. So, and the other thing is, observers are saying that this is a younger jury than typical. And I think that younger juries tend to view those kind of things a little bit more jaded, maybe, or with a little bigger grain of salt. These are the TMZ era people, and I think that they don't take those kind of things as much at face value as older people might. So, but if she'd been my client, I would have said, no, don't do it. Until the trial is done and you've decided whether or not you are going to be appealing, I think those are all, it's dangerous. In the Reed trial, grand jury testimony has been discussed in front of the jury. Is this usually allowed during trial? Grand jury testimony can be brought out during trial. Prior to trial, it is not allowed, and the deliberations of the grand jury are secret. So before trial, grand jury testimony is sealed, and the only people who are able to get it are the parties. But it is sworn testimony and can be used for the purpose of impeachment. So remember, somebody's got to open the door for impeachment evidence to come in. So in Carrie Roberts' case, which was the place where it came up most clearly, it was, she told the grand jury something really different than she testified to. And so Alan Jackson then jumped right on it and said, "But you lied to the grand jury. You lied under oath, lied to the grand jury." That is impeaching her and calling her credibility into question. One important thing to remember at every trial, there is a jury instruction. And that jury instruction, we always called it witness false in part. That jury instruction says, if you find that a witness has lied, if you find that their testimony is not truthful in one area, you can discount as much or as little of the rest of their testimony as you choose. So if you find that a witness has lied, Carrie Roberts lied to the grand jury, you can decide how much of Carrie Roberts' other testimony you believe, or whether you simply believe she lied about everything. And that is a question of fact for the jury. But so it's important for the defense attorneys to be pointing out these areas where witnesses lie. And I know everybody gets up on the stand and swears to tell the truth, but they don't. They lie constantly. Witnesses lie. I don't know how many times while I was in practice, I would have to say to clients, witnesses lie, but they swore to tell the truth. Yeah, I know. And then they got up there and they lied. And they do. They shade the truth. They do things by degrees. And sometimes they just outright lie, which is what Carrie Roberts did. She lied to the grand jury and told them that she heard Karen Reed tell Jen McCabe to Google how long to die in the snow. Her testimony in this trial was, "No, I didn't really hear that. Jen told me that Karen asked her to do that." Well, that's way different. Way different. First of all, it's hearsay. So, it wouldn't have been admissible. So now the jury will get the instruction that says, if you find that she lied about that, you can find that she lied about everything. One lie is enough to totally discredit a witness if the jury chooses that. So we're getting toward the end. Other questions? Hi, Nikki Fife. I do not have any information about Melanice, as we call her. That is Melanie Boudreau Pulowski. She is Brandon. This is in the Vallow trial. She is Brandon Boudreau's ex-wife. And Brandon Boudreau, the next case that Lori Vallow is being tried is conspiracy to murder Brandon Boudreau. Her brother Alex Cox took a shot at Brandon and thankfully missed. I don't know whether she is on the witness list or not, and whether she would be on Lori's witness list or not. But I have not heard any more about whether or not she could be a co-conspirator. We know that the only people who knew Brandon's new address, he had just moved, they were going through a divorce. And the only people who knew his new address, who could have given that information, who knew Lori and Alex and could have given them that information, was Melanie Boudreau. So there's always been some question about whether or not she was at least an accomplice of some kind by giving them the information, because they did know where he was. I don't know whether they have enough to actually charge her. It could be that they have enough and they are waiting to see how she testifies in this trial. Um, they She was called to testify in Lori's trial and ended up not testifying because she violated the court's sequestration order and watched some of the trial online. And they decided not to go down that road. And so they called her husband, Ian Pulowski, but they didn't call Melanie. I guess we'll have to wait and see after Brandon's trial is over whether they go after Melanie. I kind of think that if they were going to, they would have. And I kind of think they feel like they don't have enough to charge her. I think that they, I just think at this point they don't have enough. I think that is true for Melanie, uh, the other Melanie, and Zulema, and everybody else. Yeah. You know, I'm probably not going to pay a lot of attention to the Diddy case for a couple reasons. It's not being streamed. Uh, the courtroom's closed, so all we're going to get is drawings and reports from people who are in the courtroom. So we're not going to really be able to have the same sort of in-depth blow by blow sort of analysis that we can on cases that are being live streamed. And to be really honest with you, it's just not a case that's caught my attention. Um, Celebrity cases, whether it's Depp or whether it's Gwyneth Paltrow or this one, they're just not my jam. I know there are a lot of lawyers out there that do cover them. I know that there's a lot of folks that take a lot of interest. I know Emily D. Baker, that's really, I mean, pop culture is really her jam. She got started with Johnny Depp's case. So, there are going to be a lot of creators out there following it. And I just don't think I am. I think I'm going to be way more interested in Adelson and Koberger and some of the other big cases. I really think Reed is going to run right into Koberger. And I'm very interested in that one. And I have a new project, which I'm not really ready to talk about yet, but I'm getting so much closer. And if that all comes together, then I'm going to be busy with that as well. So, um, but there's just a lot of people covering Diddy, and like I say, it's not really my jam. I've never been a big celebrity watcher, and so I'm just sort of not in that world. And there are a lot of other people that are way more interested in um, in the TMZ celebrity lives. So. Let's take a couple last questions and then we will say goodnight. Anybody have anything else that they would like to ask? Did you say the Alberts moved cement from the basement? That seems very shady. Yes, they did. Yes, they did. They jackhammered up the cement and put down new cement. Yep. It seems very shady to me too. One of the things that we know, though, because we watch true crime, is that concrete, even though it seems like, hard surface, is porous. And we've seen many cases where evidence, particularly blood and DNA evidence, has been able to be recovered out of concrete. So because it's a very porous material and it soaks it up like a sponge. So, but yeah, that seems like a pretty radical thing to do, to jackhammer up the concrete floor in your basement. So, yeah, I mean, I think there are some real indications of consciousness of guilt. I mean, remodeling the basement, tearing up the floor, putting all the new flooring down, uh, rehoming the dog, and then selling the house. So, The jury went out for a jury view at the house, and they had to get permission from the current owners because the Alberts don't own the house anymore. Within a few months after the whole thing happened, they did a bunch of work on the house and sold it and rehomed the dog. Hi, Liz. Would the federal investigation be able to extend to the trial, therefore including the judge and the prosecution, or would it strictly be law enforcement, or is that an unknown? So I would say that the investigation is going to strictly be to law enforcement. As much as I would love to see this prosecutor and this judge get slapped down. I think it's really interesting. The prosecutor's office there is big. They have something like 100 lawyers in the Commonwealth's prosecuting office. Despite that, they had to go out and hire a special prosecutor, this Hank Brennan guy, who is the current prosecutor on this case. And to date, they have had, before the trial started, they had already paid him $250,000. And it likely will be somewhere in the $1 million range by the time they're done. So it makes you wonder why in the world they had to bring in an outsider to try this case. The first trial, Adam Lawley tried the case, and he was on his own and way over his head. Not that Brennan is any better, frankly. I think he's just as over his head. And if anything, he's more arrogant and questionable ethics. So we'll see. So I certainly would like to see him get what's coming to him. He reminds me very much of the prosecutor in the Alec Baldwin case. Carrie, it's getting late. She has the same name as somebody else that anyway, she was the reason that case got dismissed, and I think he rivals her in terms of his lack of ethics. And it's troubling. He's a defense lawyer who they brought in to try this, like her. And both of them really, I don't know if the prosecutorial power went to their heads or whether they all had ulterior motives. I don't know. But really, really unfortunate. So I definitely would like, yeah, Hank represented Whitey Bulger and other, I think some other mob connected people. Whitey Bulger was the highest profile, but I think that he also represented other people with mob connections. So, and the judge, I think her rulings have been abysmal. One thing that did happen today, which I forgot to mention, is that at one point, I think it was Alessi was doing cross-examination, and he was trying to get something in with the cell phone expert that the prosecution was objecting to, and they went to sidebar a couple of different times. And finally, he asked for another sidebar, and she said, "This is the last time I'm going to hear about this from you. This is the last time I'm going to hear you on this." And after the lunch break, she came back out, and she didn't exactly say my comment wasn't appropriate, but she did say the lawyers are all doing their jobs, and you shouldn't take anything that's said as commentary as an opinion about either side. So it appeared to me that the defense called her down a little bit on it, but she's just been incredibly biased from the very beginning. You know, I mean, they can't get a a decent evidentiary ruling to save their lives. So I don't, um, and all that she's done is just lace this trial with appellate issues on uh, on the outside chance that Karen Reed gets convicted. I think, um, you know, there are legion appellate issues. There's so many, they probably won't be able to put them all in one brief. So, yeah, um, I I I think, we're on our way to another hung jury, but I could be wrong. Acquittals are hard because you gotta get 12 people to agree, but they're not impossible. We've seen that. We've seen acquittals, recently, and actually we saw Judge Cannoni, acquit a woman. Um, Her name was Penny or Pamela, and that was a Massachusetts case where they prosecuted her because she was in an argument with her ex-husband, and he had a massive heart attack and died. And they said that she was guilty because she had provoked him with this fight. So, and actually, Judge Cannoni found her not guilty. So it was a bench trial. She opted not to try the case to a jury. Well, I think we have come to the very end. Thank you for joining me tonight. Thanks so much, for spending your Wednesday with me. I appreciate it. Thanks for all your nice comments in both the chat and the comments. If you have questions we didn't answer, please email me or drop them in the comments below. With that, I'm going to say good night. I'm going to wish all the moms out there happy Mother's Day on Sunday. It's delightful. We are going to have, my daughter is in town, so living close to us now. So we're going to have Mother's Day together. And my son-in-law's parents are visiting. So we're going to have both moms together and my mom. So we're all going out for Mother's Day brunch. And so, for all the moms out there, I wish you very happy Mother's Day. And for all of those people who fill that role in someone's life, whether they're moms, by blood, by marriage, by law, by heart, thank you for being a great mom. And we will see you all next week. Good night.